All right, so if you're gearing up for the Queensland bar exam, I bet you've been living and breathing things like hearsay and character evidence, right? But what about those miscellaneous sections tucked away at the end of the Evidence Act? Look, I know they sound boring, like just some legislative cleanup, but trust me, that's a huge mistake. We're going to treat these sections for what they really are, a barrister's practical toolkit, absolutely packed with secret weapons for your practice. Okay, let's dive in.
Just think about it for a second. What if the secret to getting that one critical piece of evidence wasn't some complex, drawn-out court application, but a really simple direct request? And what if the rules for making sure an expert's report is even admissible were just hiding there in plain sight? Well, they are. These sections are loaded with procedural shortcuts and foundational rules that are going to save you time, save your client some serious money, and honestly make you a way more effective lawyer.
So in this explainer, we're cracking open that toolkit. First up, we'll meet the key appointees. These are the folks who give evidence its official stamp of approval. Then, the big one. We are going to master the Section 134A document shortcut. It's a total game changer for civil cases. We'll cover how to navigate it, and then we'll wrap up with the forms, fees, and regulations. You know, the nuts and bolts that make it all work.
Okay, first up, let's talk about the official players in this game. See, before you can just throw certain types of evidence into a case, you have to understand who actually has the authority to validate it. These appointments are really the foundation, the bedrock for the admissibility of some of the most important stuff, like expert analysis and official documents.
What's so amazing here is just how specific this is. Section 133A gives you two and only two crystal clear pathways for someone to be officially called a DNA analyst. They can either be appointed by the chief executive of the health department, or if they're in a lab that has a deal with the police, they can be appointed by that lab's own CEO. What's the takeaway? Well, without this formal appointment, the entire validity of an expert DNA report could be up for grabs. It's an absolutely crucial check you have to make every single time.
And next, we've got a role that sounds simple, but is just as vital: the government printer, set up under Section 134. This person gets appointed by the governor in council, and their whole job is to be the official authenticator for government publications. And this is a great example of how the whole act works together, you know? This one appointment is the linchpin for other sections, like 46, 48, and 68, which are all about proving the contents of things like the Gazette or Acts of Parliament. It's the official seal of approval that stops a whole lot of pointless arguments in court.
Okay, now for the main event. Seriously, if there is one tool from this part of the Act that you need to have down cold for civil practice, it's Section 134A. This is not just some boring administrative section. It is a powerful, strategic shortcut for getting the documents you need when you need them. So picture this, because it's a super common scenario. You're running a civil claim, let's say a personal injury case, and you desperately need a report that's buried in some government department. The old school way is non-party discovery. It's a formal, often really slow and expensive court process. But your client is running low on funds and that trial date is creeping up fast. This is the exact problem Section 134A was built to solve.
And wow, the difference is just night and day. Instead of that slow, expensive, court-ordered mess, Section 134A gives you a speedy, cheap, and direct path. You just go straight to the government agency with a simple written application. The commentary on the section even says it was created specifically to be a faster, more cost-effective option than formal discovery. For your clients, believe me, this is a massive, massive win.
So we know what it is, right? It's this awesome shortcut, but how do you actually use this powerful tool? Let's break down the practical steps so you can make sure your application works and follows all the rules.
You know, the process itself is beautifully simple. First, you have to be a party in a civil case. That's a given. Second, you write up an application and send it to the principal officer of the right agency. And don't worry, we're going to define those terms in just a sec. Your application has to name the specific document you want and explain why it's relevant. You pay a small fee, and bam, you get to inspect it and take a copy. It's a super clear 5-step action plan. Okay, the first key term you absolutely have to know is agency. Under subsection 7, it's pretty much a department or public authority. But, and here's a classic exam-style curveball, the Evidence Regulation 2007 has a whole list of bodies that are specifically not included in that definition. So what's your first move? Always check the regulations before you even think about drafting an application. And the second key term is principal officer. This is the person you're actually sending your application to. For a government department, it's easy. It's the chief executive. For other public authorities, subsection 7 kind of gives you a checklist to figure out who the right person is. Getting this right is so important to make sure your application actually gets processed and doesn't just sit in someone's inbox.
Now let's get into the fine print because there are some really interesting bits in Section 134A. First, the agency has zero duty to tell the other side you've even made a request. Kind of sneaky, right? Second, the officer who gives you the document is legally protected, as if they were following a direct order from the Supreme Court. But, and this is a big but, it's not a magic wand. The commentary makes it clear that if your request is super complex or contentious, the agency might just say no, and then you're back to the old court-based procedure.
Okay, listen up. Because if you remember only one thing about the limits of this shortcut, make it this quote right here. The absolute crucial point is that Section 134A is a procedural tool. It's a new path to ask for a document. That's it. It does not, and I can't stress this enough, it does not override all the other laws about privilege or confidentiality. So if a document is protected by legal professional privilege, this section is not going to help you. This is the classic exam trap, so you really need to get this straight.
All right, finally, let's have a quick look at the administrative machinery that makes all these tools work. These next few sections might not seem exciting, but they are the essential framework, the nuts and bolts, that let the rest of your toolkit actually function.
Section 134B is a perfect example of this. It just gives the chief executive the power to approve official forms for stuff like, say, proving the identity of a convicted person. All this does is make sure everything is consistent and efficient. It's worth noting, though, that this power doesn't apply to the forms used in court proceedings themselves. And Section 135, well, this is kind of like the engine room where all the details get worked out. It gives the governor and council the power to make regulations for the act. And for what we've been talking about, this is huge because this is where the power to set the fees for a Section 134A application comes from. Without this section, that amazing shortcut we just discussed wouldn't even be usable.
And here you can see how it all clicks together. The Act and its regulations are like a team. They're partners. Section 135 provides the power, and then the Evidence Regulation 2007 uses that power to set the rules of the game. It tells you exactly what fee you have to pay for your Section 134A application, and, like we said, it lists all the bodies that don't count as an agency. The bottom line is, you just can't use one without the other. So there you have it. We've just unpacked that miscellaneous toolkit that, let's be honest, most people just skim over. So let's do a quick recap of the key tools you now have ready to go. First, you've got the key appointees, like the DNA analysts and the government printer. Their roles are absolutely fundamental to the integrity of evidence. Second, and probably the most powerful tool, you've got the Section 134A shortcut, your fast, cheap way to get key government documents in civil cases. And finally, you have the administrative roles, the background players that provide the forms and fee structures that make the whole system run smoothly.
Let's finish with a little practical thought exercise. You're acting for a client who was hurt during a procedure in a public hospital. You know for a fact the hospital counts as an agency under the Act. So now that you're armed with your new knowledge of Section 134A, what is the very first document you'd apply for? And who, specifically, would you address that application to? Now that's the kind of practical thinking that's really going to set you apart.